Assalamualaikum and hello everyone. I am Sharini and my group Christina Hazel and Alfira will present you business law, discharge of contract and remedies for breach of contract. Stay tuned.
Hi, Assalamualaikum. My name is Christina Hazel from the MK6B. Now I will present to you about discharge of contract. Okay, discharge of contract is when two or more persons enter into a contract. Each of them has responsibilities or commitments arising from the contract. For example, if he is a seller, one of his responsibilities is to deliver the product purchased to the buyer. And if he is the buyer, he must to pay the price. A contract may be discharged by performance, by agreement or consent, by impossibility or frustration, and by breach of contract. Okay, now we move to the first point, which is discharge by performance. Performance is the usual mode of discharging a contract. Under a contract, the parties to the contract are bound to perform their part in the contract. As example, the buyer has paid the price as agreed in the contract. The buyer said to be free from obligation under the contract. He is discharged under the contract. The second point is discharge by agreement or consent. A contract are created by agreement. It can also be terminated or discharged by agreement or all the parties. For example, Ali and Ain agreed to make a contract of sale and purchase a piece of land for 50,000 ringgit. Before the contract is performed, Ali and Ain come to an agreement not to continue with the contract. The contract is discharged by agreement. So Ali and Ain is no longer under obligation to perform the contract. The third point is discharge by impossibility or frustration. A contract is discharged if there is impossibility or performance of the contract. For example, Manap contracts to marry Beda, being already married to Sena, and being forbidden by the law to which he is subjected to practice polygamy. Manap must make compensation to Beda for the loss caused to her by the non-performance of his promise. And the last point, which is discharge by breach of contract. When the promisor fails to perform his obligation, there is a breach of contract. For example, a singer enters into a contract with second singer and the manager of the theatre to sing at his theatre. On the next night, the first singer absent. The second singer is at liberty to put an end to the contract. Meaning here is that the second singer's obligation under the contract are discharged.
So next is remedies for breach of contract. When there is a breach of contract, the party not in default may claim one or more of the following remedies. So there are 5: breach of contract, which is rescission of contract, damages, specific performance, injunction, and quantum merit.
So next is rescission of contract. If a party breaches his promise under a contract, the party not in breach has the right to rescind or terminate the contract. In Section 40 of the Contract Act provide when a party to a contract has refused to perform or disabled himself from performing his promise in its entirety, the promise may put an end to the contract unless he has signified by words or conduct his executions in its continuance. For the damage is the most popular type of remedy in the event of breach of contract. Damage is granted to a party as compensations for the damage, loss, or injury suffered due to the breach of contract. Contract Act Section 76 states a person who rightly rescinds a contract is entitled to compensations for any damage which he has sustained through the non-fulfillment of the contract. So next is about specific performance. Specific performance is an order of court to the party at fault to carry out the contract according to its terms. It compels the contracting party who is breached of the contract to fulfill his obligations under the contract to perform the contract has agreed. Section 22 Specific Release Act 1950, the jurisdictions to decrease specific performance is discretionary.
Okay, next is injunction. Injunction is a court's order to restrain the doing, continuance or repetition of some wrongful conduct which is against the contract. In Section 50, Specific Relief Act 1950, presumptive relief is granted at the discretion of the court by injunction, temporary or perpetual. So there are two types of injunction, which is temporary and perpetual. The purpose of a temporary injunction is to preserve the status quo of the parties pending trial. For example, to maintain the status quo of a company's board composition. Perpetual injunction is to prohibit the defendant permanently from doing an act or asserting a right which is against the plaintiff's rights. It is only granted after a full trial, before the courts and upon the merits of a case. And last but not least is quantum merit. Quantum merit, as much as he deserved, is a claim for reasonable remuneration for work done or services supplied under the contract in the event of the breach of contract. So that is all for today. Thank you for listening and enjoy your day.